Okay, it is Monday, April 22nd, 2019. It is 8:31 p.m. Central Standard Time, and welcome to week number 4, which is the start of the second half. And in this second half, we will be covering the information that's necessary for you to deal with the final exam that will be coming up. So I'm going to go right into this week's materials. Share my screen with you. Okay. And I'm not going to go over all of this because we've covered this. I do want to, okay, I'll go over week 4 assignment, then I'm going to say something about, the project. Okay. I'll be grading week 3 assignments this week. So week 4 is Gant versus Arizona, a case. And you're going to look at that case, analyze that case, answer the questions: is this legal? Use citations, references, and cover sheet, APA citations in the body, and APA references at the end. Cover page, Romans 12, double-spaced. Okay, go into that in a little bit more detail in a minute. And then the course project. So current topics. Choose and describe the circumstances around a current case or event relevant to the fourth. Remember the area that you started to write on, which you selected your topic in week number 2. Include options and a short explanation of how the case fits in your overall paper. Include a thesis statement for the project. Make sure you have citations and references as well. Cover page as well. And then these are the recorded lectures for weeks 1, 2, and 3. You can see we're week 4, and next week we'll have week 5. And also next week we will do 2 lectures. You'll see one that takes place May 3rd as well. That's for week 6 because the quarter ends May 3rd because the quarter ends May 7th. Okay, so we're rapidly approaching the end. I do want to talk about the case briefing that I did. Some of you did not follow the requirements of that assignment by including the facts, procedures, issues, holding, reasoning, and then the concurring and or dissenting opinions as well. Very important, and that I provided you with information to help you do the brief. Going back to, let's go back to course messages for a minute here, and I'm going to give you the how to brief a case. I provided that to you on Monday the 8th, and gave you a PDF document, and this I encourage you to use. Notice it talks about the facts, the issues, the holding, the rationale. These are in addition to the 4 basic elements, but dicta, don't worry about that because you won't even understand what that's about. Dissent and or the concurring opinion, okay, and things like that. So you're graded primarily on these 4, and then also on the dissent, but there was a format, okay? And I provided this information for you and told you to make sure that you follow these issues, okay? So I'm reminding you, because you had to have done that last week for cases that you're going to use for your final assignment here. So let's go back to Module 4. Oh, let's go back to the course home page because I'm jumping ahead of myself. So anyway, I wanted to bring that to your attention as you check the grading. So now let's take a look at the information for this week. So searches and seizure, which, as you should already be aware of, it involves the Fourth Amendment of the Constitution, one of the major amendments that have to do with criminal law. I've already told you it's 4, 5, and 6, but the fourth one is what we're going to talk about today. So you had to read Chapter 7, 8, and 9 of the text, and I provided you the additional information. Now, that additional information is just to help you. There should be a lot of help in there. You don't have to read that whole thing, but there's information that can help you with your written assignments. And I do that because I try to give you an edge there. A lot of professors wouldn't give you that, but I wanted to make sure you had that information. Then, of course, the PowerPoints that coincide with each chapter, you have that, which is basically a summary of the chapter for that week. So then we're going to cover reasonable suspicion, probable cause, and warrants as well today. Your discussion assignment, which is due the initial post tomorrow, seizure or not, and punishing the police. So there are 2 discussion posts that are due for each of these topics. The initial post due tomorrow night, the 23rd, by 11:59 p.m. Central Standard Time, and then your reply post due by Saturday, which is the 27th, and you want to make sure that you do provide, don't yes or no, provide details. Provide me good details. Most of you have been pretty good with that. And then I do encourage you to respond to more than one post because it makes the discussion forum more interesting. And citations and references are always welcome as well, so I don't require them. Okay. Finally, be sure to complete the written assignment, Gantt versus Arizona, and then the Fourth Amendment project, current topics that we just went over. We'll go in more details as I take a look at the rubric. I stress the rubric very seriously, and you know that by now. So you know about my motto. You know what that's all about from the week 1. So let's look at the course calendar. Okay. The course calendar is right here in front of you. And so you see your reading assignment. If you click on it, it tells you exactly the same thing I already shared with you. And then your initial posts on the topics that are due tomorrow. Then reply posts that are due Saturday. Okay. Then we get to the 28th. And your written assignment that we're going to go over in a minute. And then your project. And then, of course, your key phrase or word that I give you during the lecture to obtain your points. And that's due to 28th. Okay? And you can see as, you know, we go through next week, you can see, just to let you know, there will be a lecture on next Monday as we normally have. And then there will be one final lecture on the 3rd of May, May 3rd. very special day to me, but I'm going to be doing my lecture that day as well, okay? Because you see, the course ends the following week, so I didn't want to do a lecture on the 6th, which is Monday, so that set me up to do 2. And then you see your finals and everything is due on the 7th. That's it. Not the 8th, not the 9th, not the 10th, not the 11th, not the 12th. So it is over as of May 7th. Because actually May 8th, those of you who are in T2 and will be joining me in some of you will. Well, most of you won't because you're in the bachelor program, but many of you already are familiar with the class I'll be teaching starting the 8th, which is Introduction to Criminal Law and also Drugs and Crime. So anyway, so that's how that's going to work, okay? All right, so now let me get to, let me do this. Let me do this. So anyway, I had to stop that music. And so anyway, no interruption here. Sorry about that. And then let's get back into Module 4. And let's go over the assignments. So the assignments are based upon the rubric, and notice that this is the course project, and the course project involves a 1 to 2 page paper. Now, when you have a 1 paper at least, make sure, I already say this, you run your papers through Grammarly. And it is so important. You guys know about Grammarly now because you're in the bachelor program, because you had to use it specifically if you were in my classes. Some professors don't require it, but it is important so that I can see that you understand and apply critical thinking in your written assignments. So it's very, very, very important. So you're going to find a current case or a current event that deals with the area that you chose in week 2 for the 4th Amendment. Now, stay with that, all right? Describe the circumstances surrounding the case or the event. Include your opinions. Include your thesis statement. And it says a thesis statement should present your main idea in 1 or 2 sentences, okay? So I should know where you're coming from in terms of your topic. And then your paper should be proofread for correct spelling, grammar, and punctuation. Remember APA citations and references. If you click on the rubric, look on this, you'll see that your written assignment, what is involved there again. And you already saw the rubric, but you saw when it is due, okay? Very, 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 very important. Make sure you do it APA formatted. And then your written assignment, dealing with Gant versus Ohio. This is the citation for the case. And it says a relatively new Supreme Court case. Well, for our purposes, it is. And it limited the search incident to an arrest exception because there's one of the exceptions to obtaining an arrest warrant. So you're going to research the case and skim the actual opinion. Apply the rationale found in this case to the following fact pattern in a 1 to 2 page paper. So you're going to read this fact pattern and apply it. And I'm going to make sure. Now, listen to me good. I repeat, do not give me these facts to fill up your page because I'm not going to consider it. I want your analysis, okay? And I don't need you to give me all these facts. To the extent that you are intermingling them with your critical thinking and your analysis, fine, but not, some people will take and copy this whole thing and use this to try to get, no. And then the question is, what happens in this scenario? Is it legal under Arizona versus Gantt? If it's legal, explain why it's legal. Don't just say, yes, it's legal. If it's not legal, explain why it's not legal and provide some rationale and support for it as well. And then your discussion posts that are due. You know what those are. There are 2 of them. All right. And then your live classroom lecture. Those are the assignments for this week, week 4, that, of course, you already know. I'll just click on it again and show you when it is due. It's due Sunday. Everything in this area here, with the exception of discussion posts, are due by Sunday at 11:59 p.m. Central Standard Time. Your reply post and an initial post, you know how all that works. And you should be aware, I'll repeat it again because some students don't get it, is that if you submit a reply post and an initial post Sunday after the forum has ended on Saturday, you're not going to get any points. If you submit your initial post late, you will lose points for it being submitted late, your reply post would have to be submitted no later than that Sunday to get any points for it. And then, of course, you will lose a point because it's technically late, but I'm giving you a chance to do it that way. Okay? So keep that in mind. Students submit sometimes really good posts, but it's done Sunday. They submit initial post and reply post Sunday. Forum's over. It ends Saturday at 11:59 p.m. Central Standard Time. Okay? In this case, to put a date on it, we're talking about April the 27th by 11:59 p.m. Central Standard Time. If you submit both posts by the 28th or after, it's no deal. It's going to be 0. Okay? And I can't change that. That's the school policy. So that's it for the assignments for that week. So now let's talk about what we're dealing with here and what you should have discovered or will be discovering from your reading and, dealing with the 4th Amendment, dealing with from pat down the warrant requirements and exceptions, not all, but just generally, and then the consequences of 4th Amendment violations, what happens to cases where there are, and difference between probable cause and reasonable suspicion. So we're going to talk about reasonable suspicion, probable cause, and warrants right about now. Okay, so now you have to understand, first of all, the difference between probable cause and reasonable suspicion. And they don't mean the same thing, and they are very, very different. In fact, the higher standard of the 2 is probable cause. Okay, and the search is not the same as a seizure, and a seizure is not the same as an arrest. We'll talk about that in just a few minutes. So just this little chart here kind of gives you a bird's eye view and helps you in your mind, and it gives a major case. So let's talk about first reasonable suspicion. So when you stop or frisk, first of all, number 1, the stop that is done, what we call the Terry stop, based upon Terry versus Ohio, which is mentioned down here. If you want to review that case, and some of you might be familiar with it already, it is known as the stop and frisk case. And what that means is that individual who a reasonable person could reasonably believe a person is or has been engaged in criminal activity. A reasonable person. Now, that reasonable person is based upon the standards of, I hate to keep saying it because it's not a good way to say it, but that's the only way to say it, is a reasonableness. So it's like this, people, and this is how I explain it, is that when a person is using the reasonable person standard, they're using the average person. That's another way that I hear it being said. Now, the key thing is this, is that everything around, or as we use the term in here, and it's totality of the circumstance. So we take into account all the circumstances and should be based on specific facts. For example, let me say this. It's 12 o'clock midnight, all right? And a person is peeping in a window in a store. Let's not use a house because that brings on a whole nother issue. But let's say in a store, and the store is closed, and they're peeping in there. And as that person is peeping in there, the officer is observing that individual, and you know that individual may even possibly try to check the doors. And don't let the individual have something in their hand, you know, that might break it, or some kind of tool. That's like, oh yeah, that person is not just carrying that, but not they're using it to try to get in. And so a reasonable person under those kind of circumstances would probably believe that individual is up to no good and is about to commit a possible crime or burglary, B&E as we call it, breaking and entering, that kind of thing. And so what had happened there is the police officer can get that person, ask them their name, and they should provide them their name, and they should be able to take the person and do what we call pat them down. Okay, now the purpose for patting them down is to determine if they have weapons, if they have any weapons, and it's for the safety of the officer, and it's also determine whether they have some contraband. Now, if you pat a person down and there's something really bulky, you can ask them to take it out. And if they refuse to take it out, then at that point in time, then you can possibly place that person under arrest. And then you could check into the pockets. But here's the deal. Let's say, for example, you pat a person down and you feel in their pocket what any average person would recognize as a gun. I don't care whether it's a toy or if it's a real gun. In that case, then that individual would then be able to seize that item and charge him with whatever crime that may exist. Now, if that person has, you know, the proper papers for carrying that weapon, that's a different story. But the reason for this is because it appears that that person was about to commit a criminal act, or either they have just finished being engaged in a criminal act. So that's kind of like when you review Terry versus Ohio. So that's a reasonable suspicion. That is not probable cause, people. Terry does not reach that level. So now, let's go to the other side of the equation here. Let me see if I can move this out of the way. Yeah, let's move that up here. Okay, so now, let's look at the highest standard, as I already said, and needed for a warrant. There must be probable cause to have a warrant issued. There must be probable cause to arrest. There must be probable cause to commit a search. Now, there are exceptions, but let's just for the moment here operate on the basis that probable cause. So what is probable cause? It is very simply this. It's a reasonable belief. Sounds almost like the first, but it is not. That a person committed a crime. And it's also used as a standard for submitting cases to the grand jury. So I guess here's the deal. Let me give you some examples of probable cause necessary to obtain a warrant. Let's say you're a police officer and you see a person, no, you're driving past a person's residence, and you walk up to the residence, you're outside, all right, and you smell, you know the odor of marijuana. So you can get a warrant to state your experience and so forth and so on, and that warrant would be issued by a judge or either a magistrate. It's a neutral party, and it specifies the warrant and what the basis of the warrant. So this, in this case, would be what we call a search warrant. So a warrant would be issued to check X premises, and then that person would serve the warrant and then be able to check. All right? Now, in the warrant, there are a lot of rules that I won't get into because there are some ways that you have to make sure that you use the warrant properly, such as we deal with a search incident to an arrest. I'll deal with that later. But the warrant itself, probable cause, now notice the difference. Reasonable suspicion, is it necessary to go to a judge before you can exercise a Terry stop? Yes or no? Type it in there. Type it in the chat box. Yes or no? Is it necessary to go before a judge to perform a Terry stop? Is it? Nobody say anything? Okay, the answer is no, and that is a correct answer. Because notice what I just said. When we deal with the probable cause issue, there's a court that's going to be involved unless there's an exception. But probable cause is determined by usually that magistrate or judge. So to obtain that warrant, there's an issue about dog sniffing. Now, there are some people who believe that dog sniffing will allow the police officer to go into the place because the dog recognizes the smell and is trained for that. Can't do it. Got to have a warrant in order for the dog sniff to even take place. The police officer, you don't have to do that because the officer is in a place where they're near the residence and they can determine. Let's say they went into the hall, public vestibule or something like that, then they can do that. So then, and those are the kinds of things. That's just one example of a warrant. Now, arrest. Arrest, as far as probable cause, you must establish, again, there's a warrant issued unless there is, for example, a search that takes place and then it uncovers a weapon. At that point, that weapon is obtained, such as in the Terry stop, that weapon. Then at that case, then that person is placed under arrest because probable cause exists that the person has committed a crime. And that's it. Now, that's just one example. So I'm just trying to make it as simple as I possibly can. And then as far as the search is concerned, you again need a warrant to conduct a search. Now, the warrant must specify the address, the areas, and what it is you're looking for, what you suspect you're looking for. Let's say, for example, that you're looking for a cache of weapons, a bunch of weapons, and you maybe going through that individual's pocket or something. You might not be performing it correctly, because the search for the weapons, what you're looking for, a cache of weapons, can't fit into somebody's pocket, but it can fit throughout the house. I have seen situations like this, where a search warrant was issued, and they were looking for some items and or an individual. And I've seen, and I had a case like this, where the police came in. They came in and searched the premises, and they were asking questions of the people, and the people weren't giving the answer they wanted. And they said, "What is this?" And they went up on the mantle piece and took down, oh, they're looking for marijuana or something. So they took what is clear to be an urn for a person's body, and they look at it, and then they say, "Oh, we don't know what this is," and they'll pour it out. That's wrong. That's wrong. So, again, a court determines probable cause unless you're in a situation where there are some exceptions. So what we say here is you can review the entire Fourth Amendment, which says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and that it shall be not violated, and no warrants are going to issue but upon probable cause. So that's what I said. You have to have probable cause to have a warrant issue, and it's supported by an oath or an affidavit that is submitted to a judge, where the officer is determining what they believe is present, and that the judge issues the warrant based upon the oath and affirmation of the officer. And as I said, describing the place to be searched and the persons or things that they expect to find. All right? Now, let me say that if you get a warrant to search premises for marijuana or drugs, and you run across guns, can you seize those guns? Yes or no? Yes, you can. Because when you get into the issue of search incident to an arrest, that's because you don't know that yet. But no, the guns. So if you're there looking for marijuana and there are guns, and it's determined that the person doesn't have the proper credentials or paperwork for those guns or permits, you can take those guns, because then a person can be placed under arrest, of course. All right. So let me show you. In order to make an arrest, enter a home, or conduct a search, there are some exceptions. And now I'm getting ready to open it up, and then your answer would have been different. I kind of tricked you. So if a person consents, so if a person says, "Okay, yeah, you can search," the officer don't need a warrant. So, but the consent must be voluntarily. Like, not if you got a gun on you, can I search? Not if you're threatening to place them under arrest, unless you let them, they let you search. It's not. That's not. Voluntarily means voluntarily. So no warrant is necessary in a voluntary consent. And all of the circumstances are looked at to determine whether it's voluntary. Again, not too many people do things voluntarily when a weapon is put on them, pulled on them, put at their head, or either pointed at them. Or even if they see the officer draw the weapon and not point it at them, and they say, I want to search the premises, and then they come back and say, well, the person gave consent. Yeah, they gave consent because they didn't know what you were going to do with that weapon. So it was not a voluntary. Okay, that's the key word is voluntary. And courts look very seriously to determine what is. Another exception, here we go. Search incident to an arrest. So once an arrest is made, all right, so the officer may conduct a warrantless search of the area in the arrestee's immediate surroundings for the purpose of the safety of the officer or to prevent destruction of evidence. Now you see why I said that if they're searching for marijuana and they come across guns, why that search for those guns would be legal. Now do you see why I said that? Okay, all right. Like I said, I tricked you. That was a good answer without knowing this. Now that you know this, you say, oh, yes. Okay, now look, the Gant case, you heard about that case somewhere. I'm not going to tell you where if you don't know by now, which limited the exception of a search incident to an arrest even more. When the court said that in a search of a car, see, and cars, see, it's been some very interesting things with cars, because cars are mobile and moving and stuff like that. Says that in the search of a car following an arrest, the officers can only, listen to that word, only search the car if they have a reasonable belief that the arrestee's car is within his immediate control, or if the evidence of the crime for which the person is being arrested could be found in the car. For example, if a defendant is arrested for driving while his license is suspended, the officers could not use the second part to search the car because it's not relevant, because there'd be no evidence of his driving while his license is suspended found in the car. So you can't use that. But let's say, for example, if an individual is stopped and they're driving under the influence of law, under the influence of alcohol or drugs, okay? In that case, then the police could then search the immediate area that is under control. Now, does that extend to the trunk of the car? Yes or no? That's right. Because it's not in the immediate control of the individual. Because remember, the main purpose is if there's reasonable belief that the car is within immediate control, or if the evidence of the crime for which the person is being arrested is found in the car. The trunk is a part of the car. However, though, if they're driving under the influence or something like that, that whatever alcohol is in the trunk of the car is probably not going to apply. But what is found inside that car, is going to be. Now, let's say you open up the glove compartment of the car for that person driving under influence and alcohol and all that. Is that a proper place to look for some alcohol in the glove compartment? Yes or no? People don't put alcohol in the glove compartment? You don't think alcohol could fit in the glove compartment? Most glove compartments now, alcohol can fit in. It doesn't matter what the size of the bottle. It's the point, or a can of beer or something like that. So the point of the matter is that the answer is yes. And the reason why I was asking that is because now they find a gun that is not registered and it's illegally obtained in that car and transported, that person then can be placed under arrest for that and charged. That evidence would not be able to be suppressed because, once again, it says that the reasonable belief that the arrestee's car is within his immediate control if evidence of the crime could be found in the car. So the gun could be found in the car, under the seat. You know, you can put your hands in between the seats. You can look in between the seats. But definitely the glove compartment, definitely. And it makes sense if you stop and think about it. If you try to say, well, small bottles, it doesn't matter. It's still, you're going to have that same situation, all right? So that's an exception. Here's one of the clearest examples. Plain view, we call it. If an officer legally searches an area with a warrant or with the consent of the person, owner of that space, the officer comes across contraband, evidence of a crime, that is something that's illegally possessed, in their plain view, they may seize it without a warrant. In other words, they don't have to go back and get a warrant later. It wouldn't make sense, because if they had to go get a warrant and they have to go before a judge and all of that stuff, what do you think is going to happen to whatever it was that they saw? It's going to be what? You got it. It will be disappeared or destroyed. Absolutely. And so it doesn't make sense. Look, common sense has to apply in some of this stuff. So plain view exception. So that's why I say, for example, you go in to check for drugs in a house, and you get there and you run across guns that are sitting all over the place. So those guns are in what we call plain view. And so as a result, there's not the necessity for a warrant. That's another exception. Automobile, and you know what? You could go and you could research and pull cases up under these theories, and you could see cases that actually cover these issues if you desire. Automobile exception. Now, automobiles, because they are mobile, I kind of touched on that a little earlier when we were talking about the search incident to an arrest. So it says, since there is an increased risk that evidence can be destroyed. So officers do not need a warrant to search a car where they have probable cause that there is evidence of a crime within that car. Now, let me give you an example of a situation I'm aware of. Well, let me finish this, and then I'm going to do this. It also applies to the mobile vehicles like boats and things of that nature. This rule is limited, though, to areas where the contraband could be found. For example, if probable cause that a bicycle was stolen and is in the trunk of the car that is being searched, the officer cannot open up the glove compartment to look for the cycle. Bing! How come? Because of what I said earlier. The bike, you wouldn't be looking for a bike in the glove compartment, okay? But the point of the matter is, so that fits. Let me give you an example. There's a police department in our area, the Aurora, Illinois Police Department. And I was at a seminar, and they shared this information with us. They were trying to show us this system that they had where a person was seen on Facebook promoting that they were dealing drugs. And because they were able to determine the location, the location led them to the parking lot of the police department where they were doing the check. So the person was in the parking lot actually with a car full of drugs. Okay, now, here's what happened. So the police went downstairs, and they confronted the person, and, you know, the person didn't have the amounts that they needed to find in there. And they asked the person, so in that instance, do you think that those officers had probable cause to search the car because the car is mobile? It may appear that way, but that's not true. Because of the fact that the person was sitting in the car, apparently not doing anything illegal, and they had suspicion that the drugs were in the car, in the trunk. They had to ask the person if they could check the trunk, and the person said no. So what they could do is they could impound the vehicle, but could not search it until they went to a judge. And they have electronic ways of doing it now. They had a judge, they got the warrant, and brought the warrant back. And then the person was forced to open up the vehicle, and in the trunk was a whole cache of marijuana. I mean, I've forgotten how much. It was a large quantity. But the thing was, they could seize the vehicle, but they couldn't search it without getting the warrant. But they did have probable cause by presenting what they determined or expected to find and the place where they thought they would find it. Now, and so a car that is mobile, it says there's an increased risk that evidence may be destroyed. Officers don't need a warrant where they have probable cause that there is a crime within the car. Okay, here they did. But the argument could be made that just because the location that they led them to, and they didn't see anything, they couldn't find anything on the person in there, that they could search the trunk without a warrant. But what they could do is they impounded the vehicle, and they were able to do it. So it's kind of tricky, and and it also depends on jurisdictions. So here's what happened in a case like that, is that they could have possibly said, open the trunk, and the person said no. Then they says, you're under arrest. Under arrest for what? Well, first of all, number one, in a situation like that, the car wasn't really mobile because the car was sitting there, and they had surrounded the car, and the person couldn't go anywhere. So then in order for them to search the car, they had to get a warrant. That's the point. So usually searching a car within don't need where they have probable cause that there is a crime within a car. If you find some drugs inside the car or either weapons inside the car, then that's when we come to that point. But this instance, I told you, there was nothing. Yeah, but what about what they found on Facebook and the location? Still, that was just enough for them to be able to have probable cause, which had to be run by a magistrate in order to do this right, because a sharp lawyer, which I was one of those defense attorneys as well as a prosecutor, but I was a defense attorney, would file a motion to suppress it and get that thrown out, that evidence not being, even if it was as much as it was, they could keep it and destroy it, but they couldn't charge the person with it. So the rule is limited to areas where contraband could be found, all right, and those kind of things. So that's the automobile thing, and it's tricky, and it's changing. Exigent circumstances is where there is a threat of harm, emergency, or destruction of the property, which we talked about earlier. Officers can enter premises without a warrant. So let's say, for example, a person runs into a house or so forth, and they had some drugs or a gun or something on them. Then they don't have to go get a warrant to go in, and they can enter the premises in that case. So it's exigent. And then finally, one we talked about earlier at the top, Terry versus Ohio, officers may stop and frisk if they have reasonable suspicion based on articulable facts that the person has committed or is committing a crime. That brings us back up to reasonable suspicion. So this video here, a defense attorney talk about more exceptions, and I'm not going to go into those. So if you decide you want to take some time to look at that, feel free to do so. So what are the consequences of Fourth Amendment violations? I kind of told you that already, is that if the law is not followed by the officer, then the evidence that is seized can be quashed, as we use the term, not squash, quashed, by filing a motion to suppress or suppressed, and that evidence cannot be used no matter how strong it might be. So, and the reason for that is that the courts are required to make sure that the police officers perform professionally in protecting the Fourth Amendment rights of individuals, not be so hasty to get an arrest or bring a person in that they violate their Fourth Amendment rights. And that's just kind of a blanket statement, but you know, it's not as simple as that. Trust me, we have to go through a lot of hearings, filing the motion, and then so forth. So we've discussed the pat down to warrant, the warrant requirements, exceptions, the consequences, and then we dealt with the difference between probable cause and reasonable suspicion. Any questions? Any questions? Nobody's typing anything, so the answer is probably no. Okay, so it is about 9:23, and okay, so I've given you a lot of information, but see, what I just kind of like gave you is a thumbnail sketch of, if you read those chapters and use the materials that I gave you, you'll see what I'm talking about. Now, let me tell you something that I always hear people say. They say, well, I heard what you said, Professor, but I've seen things go differently. Yes, because you know why I say that? Is because cases are ever changing, jurisdictions change, depends on the judges. Because remember, here's the deal. The cases that you see are cases where somebody lost, and that means that they appealed the decision. Let's say, for example, if the judge decided to suppress some evidence in a motion, then the prosecution can appeal, and it can go as high as the United States Supreme Court, and then it actually gives a definitive ruling. But it takes a while for those kind of things to happen. And so, you know, like I said, the Gant versus Arizona case is one that you want to look at because it, you know, 2009, and like I said, it's kind of recent, but the way that the law operates is they chip away at issues that some people might argue is a violation of the Fourth Amendment. Like there's, for example, a whole argument which doesn't so much go into what we're talking about, but you're familiar with the Patriot Act. I teach criminal law, and then also in the earlier constitutional law course, the 11-week course, we covered the Patriot Act and some special Fourth Amendment issues involve search and seizure and also arrest. And the question was, under those circumstances, is there possibly giving up some rights that the people have in order to do so? And the answer is usually, Yeah, but it's so minor because you balance the protection of the individuals in this country from the terroristic activity that can go to the epidemic proportion like September 11th, like the Oklahoma City bombing, you know, and other incidents like that, like the one at Mandalay Bay in Vegas, um, these school shootings and all these kind of things. But we're primarily dealing with terrorists. We're talking about organizations that are foreign governments that are infringing upon the government of the United States to hold them hostage by threatening to kill innocent people, sending anthrax through the mail, poisoning the water system, all kinds of stuff like that. So, but that's Fourth Amendment stuff, but that's a whole nother ball game. What we've talked about today involves dealing with the issue of how, and law enforcement in general, the Fourth Amendment is viewed. And again, we have not even really scratched the surface that much. When I was in law school, we had a course that we dealt with the Fourth Amendment. We had a course we dealt with the Sixth Amendment. We had a course we dealt with the Fifth Amendment. And, or either we had weeks that we had to deal with it. And so, trust me. And then even after you graduated and you were practicing law, if you had a case, you still had to be kept up to date by seeing the cases that are decided across the country, ultimately all the way up to the Supreme Court if possible. So I'm saying that it's not something that is yes and no. We used to say in law school, it depends. And that's where we would leave it. So, and that's where I'm going to leave it with you. So anyway, it's about 9:27. Thank you for coming out tonight. I do want to say this to you, and this is how I'm going to say it. The phrase that I'm looking for tonight is probable cause. That's it. I'm not going to repeat it, and that's it. So you submit that, and you get your points. Make sure, though, that it's done no later than Sunday night, 11:59 p.m. Central Standard Time. That's the neat part about coming to the lecture, is that you can do it right afterwards, and then you'll see how quickly I give you your points there. So in this case, in this course, it's 10 points. In most courses, it's 5 points, but in this case, because it is you're in the bachelor completer program, then in that case, it's 10 points. So I'm going to say good night at this time, and see you next week at the same time for our Week 5 lecture. Good night.